Guys, the movie for this is going to be so good. So the SEC has filed a new letter in response to the VeriDAO's supplemental amicus brief regarding the Kraken FOIAs. And I'm just going to jump straight into it. And we can see here document number 127, dated July 14th, 2025, is a main document and it's a letter. And this is actually the letter right here. And I'm just going to read through it with you. It's only 2 pages. So you can see July 14th, 2025, Honorable William F. Kuntz II, United States District Judge, Eastern District of New York. Regarding SEC versus Middleton et al. Dear Judge Kuntz, Plaintiff, Securities and Exchange Commission, SEC, respectfully submits this response to the July 10th, 2025 letter of amicus curiae, VeriDAO, which seeks to supplement VeriDAO's amicus brief in support of the defendants' Rule 60B motion to vacate their settlement agreement with the SEC. Now, I think it's important to come to this because the SEC did this last time and they did it 3 times in this document. So I'm actually going to talk about this. So Rule 60, relief from a judgment or order. So what actually is being filed is a 60D3. So 60D right here. Other powers grant relief. This rule does not limit a court's power to, number 3, set aside a judgment for fraud on the court. So this is important because there is no precedent has said there is no time limit for fraud on the court. What the SEC is referring to time and time again, and I believe is trying to confuse the court here, is Rule 60B. So B here, grounds for relief from a final judgment order or proceeding on the motion and just terms the court may relieve a party or its legal representative from a final judgment order or proceeding for the following reasons. 3, for fraud. See how it's not fraud on the court? This is just for fraud, misrepresentation, or misconduct by an opposing party. There's a big difference here. So there's a time limit of, I believe, only a year. Whereas 60D3 here set aside a judgment for fraud on the court. There is no time limit for this. So I feel that the SEC may be trying to confuse the court here with this little sleight of hand by constantly calling the defendant's Rule 60B motion when it actually should be Rule 60D3, motion to vacate for fraud on the court. All right, so I'm just going to carry on from where I left off. So the VeriDAO alleges that the document it recently received from the SEC in response to a prior FOIA request shows that the SEC knew early in this case that Veritaseum LLC, rather than the defendant Middleton, owned a certain Kraken account, and that this fact somehow undermines the SEC's opposition to defendant's Rule 60B. See here? 60D3 motion for fraud on the court. For the following reasons, the VeriDAO's contentions are meritless. First, VeriDAO's letter fails to explain how the document it attaches even show that Veritaseum owned the Kraken account at issue. VeriDAO does not cite a specific page of those documents. In any event, none of the documents appear to address ownership of the Kraken account. Well, no, they don't, but the flash drive is titled Veritaseum. So how would the Kraken employees know what account they're even talking about if they're calling it Veritaseum? If Kraken has Reggie listed as a personal account, first of all, Kraken has pulled their business out of New York, so it's impossible for Reggie to have a personal account. So let's not ignore that. But further, if the SEC is calling it a Veritaseum account, wouldn't that confuse Kraken if there is no Veritaseum account? Why would they be discussing a Veritaseum account back and forth if there was no Veritaseum account? So clearly, there's a synergy here with using the word Veritaseum. Kraken knows what the SEC is talking about because the account is actually titled Veritaseum. Otherwise, it would have no clue what the SEC is even talking about, right? Because the SEC is claiming it's a personal account. So why is the SEC even using the name Veritaseum? It makes no sense to me. All right, let's carry on. So second, as the SEC explains in its opposition to the defendant's motion, shortly after the initial TRO hearing in this case, before defendants agreed to a preliminary injunction, and well before defendants consented to the final judgment in this case, the SEC corrected the record and acknowledged its prior inadvertent misstatements regarding the nominal ownership of the Kraken account. Okay, I'm going to stop it here. First of all, the SEC did not correct the record at all. Patrick Doody corrected his first declaration with a second declaration stating that the account was in fact titled under the name Veritaseum and not Reggie Middleton, as previously claimed in his first declaration. This is the only mention of a correction at all. So the SEC lawyers did not correct the record. We just need to be clear on that. This is the main reason for the TRO, the freezing of all Reggie's assets, is because they claimed he was dissipating assets through a personal Kraken account, which is not. It's not. They never corrected the record. They just continued on to issue their temporary restraining order. Now, I need to make it clear, I am not a lawyer. I am just reading publicly available information and adding my own opinion to it. So you can take that for what it is. It is solely my opinion. But my opinion is that the SEC never corrected the record. I would love for them to actually show where they did correct the record and prove me wrong. But as it stands, they have not corrected the record. So moving on. Thus, Veritasium's alleged new evidence adds nothing material to the current record. For the reasons set forth in the SEC's opposition brief, even if the new documents establish that Veritasium LLC, not Mr. Middleton, own the Kraken account, which they do not, they would have no bearing on the defendant's Rule 60B, see again, they do it again here, 60D3 motion, and would not support VeriDAO's contention that the SEC engaged in fraud on the court. So there, they should know right away that 60B3 is fraud on the court. This seems purposeful to me. Again, I'm just sharing my opinion on what I'm reading. See SEC Opposition, ECF number 124 at pages 11 and 15. Ben Curavilla. Respectfully submitted, Ben Curavilla. So, going back here to the footnote, to the extent VeriDAO refers to a picture of a thumb drive containing documents that the Kraken produced to the SEC, that includes the words Veritaseum Inc. NY 09755, ECF number 126-1 at page 26. These words do not refer to a Kraken account. Rather, as is evident from the additional correspondence attached to VeriDAO's July 10th letter, Veritaseum Inc. NY 09755 is merely the name and number the SEC assigned to this investigation. For this same reason, the SEC subpoena to Kraken was also titled Veritasium Inc. NY 09755, ECF number 126-1, pages 17 to 21. So again, why is the SEC using Veritasium language if they're looking for a personal account? Wouldn't they be asking for the Reggie Middleton account? Why would they confuse Kraken with the Veritasium language if they believed it was a personal account? To me, this makes no sense. Common sense would suggest they're looking for the information related to Veritasium that the Kraken account would have, not Reggie Middleton himself. So there is a reference here to a company account. There is a reference here to a company. That company is Veritasium. How would Kraken know what the SEC is talking about if it's not a business account labeled Veritasium? Again, this doesn't add up to me. So while going back here, the FOIA requests do not actually show or specifically say that the Kraken account was a business account titled Veritasium. It definitely suggests it with this name of the flash drive. And it also says multiple times, as early as May 30th, I believe, 2018, that the SEC was in possession of these records. All right, hold on a second here. Hold on a sec. Let's just read this last paragraph one more time. So even if the new documents establish that Veritasium LLC, not Mr. Middleton, owned the Kraken account, which they do not, so they're suggesting that the FOIA replies from Kraken don't actually state the name or title of the Kraken account. But we know that Reggie Middleton lived in New York and Kraken does not do business in New York, so Reggie couldn't have had a personal account. But regardless, they would have no bearing on the defendant's Rule 60B, and I'm going to correct this every time I see it. It's actually Rule 60D3, motion to vacate for fraud upon the court. And they would not support VeriDAO's contention that the SEC engaged in, quote, fraud on the court. But it does, so hear me out. What the FOIA requests actually do show is that the SEC knew as early as May 30th, 2018, over a year before they suggested this narrative that Reggie was dissipating assets, investor assets, through a personal Kraken account. We know that the SEC knew as early as May 30th, 2018, the status of that account and the title of that account. And we also know for a fact that Patrick Doody corrected his first declaration with a second declaration stating that the account is in fact titled under the name Veritaseum LLC and not Mr. Middleton personally. These are two facts that we know. Now, sure, the Kraken didn't actually say or suggest what the name of the account was, even though it says it on the flash drive, which, again, adds a whole other level of confusion in the communications between Kraken and the SEC. But we do know that the SEC knows as early as May 30th, 2018, what the status of that account is. And we know, again, Patrick Doody's second declaration, that the account is in fact titled under the name Veritaseum LLC. Now, even though Patrick Doody, I'm going to hammer this home, I'm going to say it again and again, even though he corrected his second declaration, the SEC lawyers never corrected the record. So they pushed on with the narrative that these assets were dissipating through a personal account so that they could issue the temporary restraining order, freezing assets. And we've also learned through these new revelations from Franklin Jason Siebert, the TRO transcript, that Jorge flip-flopped and admitted that it was a business account and tricked the judge into freezing this account as a business account, which in fact was a business account, because the judge was refusing to freeze personal accounts. So again, I'm not a lawyer. This is merely my 2 cents or opinion based on publicly available information. I could easily be wrong, but I felt like I've got a pretty good argument here rebuting what the SEC is submitting to the court. I'm sure Franklin Jason Siebert, Reggie's attorney, is going to have a much better argument than I have. But yeah, and I'm looking forward to tonight. I'm actually interviewing Michael, Crypto MM, and Adam, We the Sheeple, who actually were instrumental in obtaining these Kraken FOIAs. So I'm really excited about that because the timing couldn't be better. So look for that tomorrow. So thanks again for all your support. I really appreciate it. And I will see you next time. Guys, the movie for this is going to be so good. So I was just wrapping up that last video and I got word of a new letter in reply to the SEC's letter. So let's just jump right into that. So we have regarding SEC versus Middleton et al., VeriDAO's final reply in support of defendants FRCP 60D3 motion to vacate order for fraud upon the court. So dear Judge Kuntz, VeriDAO has received and reviewed the SEC's July 14th, 2025 response to VeriDAO's July 10, 2025 supplemental letter brief to the court. In light of the same, it appears that there are some misunderstandings and continued mischaracterizations that must be addressed. As such, VeriDAO offers this letter as its final reply on the matter. As a preliminary issue, the SEC's July 14, 2025 letter makes multiple references to the defendant's Rule 60B motion, quote unquote. For clarity purposes, with the belief that the SEC made such references inadvertently, defendant's motion is grounded in Rule 60D3 and is in no way related to Rule 60B. Additionally, in its letter, the SEC does not deny knowing the true ownership of the Kraken account as early as August 8, 2018, as page 14 of docket entry number 126-1 shows. Rather, the SEC argues instead that VeriDAO's submission merely fails to point out that page. Page 14 of docket entry number 126-1 demonstrates a reply from Kraken on July 26, 2018, identifying one account responsive to the SEC's subpoena. That same page shows a packet of information was received by the SEC responsive to that subpoena on August 9, 2018. These events, when reviewed in conjunction with docket entry number 6 and docket entry number 43, illustrate that the one Kraken account offered to the court by the SEC as evidenced in support of the SEC's TRO was already known by the SEC to be owned by Veritaseum LLC. Notwithstanding the same, every document and argument submitted to support the asset freeze on August 12, 2019 states that same Kraken account was the personal account of Mr. Middleton in order to create a false emergent scenario to support the extraordinary relief granted by Judge Hall. Lastly, to the extent that the SEC continues to maintain its position that the SEC quote unquote corrected the record by virtue of Mr. Duty's supplemental declaration regarding the Kraken account, VeriDAO reiterates prior argument made by the defendants on this matter. See DE 43, page 13. Line 13. To be clear, there has never been a correction up to the record by the SEC or any amendment to any of its filings in support of the TRO or asset freeze. That demonstrates a clarification to the court the SEC had known the true ownership of the Kraken account long before August 12, 2019. In the event this court is not satisfied that the SEC's own documents do not provide dispositive proof, when combined with the record, that the SEC knew the truth of account ownership on or before August 12, 2019, and specifically withheld that truth from the court while fabricating ownership, then an evidentiary hearing should certainly be had in this matter. Respectfully submitted, Seth C. McCauley of Kenny Hertz Perry, LLC. I don't think I need to add too much more to that. That's pretty amazing. Like I said, the movie of this is going to be really good. All right, I'm going to end it there, and I'll catch you next time.